So of course that's exactly what I just said, was that it can't be any more lenient than the federal standard, and that's what we're dealing with here. But before we talk about force, and normally in a classroom setting, I ask police officers around the country this question, and a lot of times they have a difficult time answering this. But if I were to ask you the question, what is force? Can you give me a definition of force? You know, we all probably recognize excessive force when we see it, or we think we do, but to be able to define force in law enforcement sometimes becomes difficult. So what we've used as a simple way to define force is to look at the definitions of assault and battery. Because in reality, as a law enforcement officer, there comes times when we have the legal right to assault and batter people in order to gain control or defend against some type of aggression. So if we define battery and assault, then we have a good definition of force. So the definition of battery, of course, is any form of intentional, non-consensual bodily contact that a reasonable person would consider harmful or offensive. So in order to batter someone, you have to actually touch them. There has to be that non-consensual offensive touch. Assault, on the other hand, we don't even have to actually touch somebody to assault them, but if we place somebody in fear that they're going to be battered, then that's an assault. So maybe we touch them, maybe we don't. Both assault and battery can come into play. That's why a use of force as a police officer, as a state trooper, begins when we arrive on the scene. We start using force at that time. Just our mere presence is a use of force, because the person could possibly believe that an assault's going to occur, that there's going to be a non-consensual touching of that person. So it starts with our presence, our mere presence. Then it escalates on up to verbalization. We would like to have all police officers, all troopers around the country have good verbalization skills. And 99% of the time around the country, the people that we deal with, whenever we talk to them and we use good verbalization skills, then they comply with what we're asking them to do. They follow those orders, and that's as high of a use of force as it has to go. Is that just presence, and then that verbalization. Several years ago, in 1989, if you were a police officer prior to 1989, the use of force rules were much different than they are now. Before 1989, the federal standard for use of force was set out by a Supreme Court case called Johnson versus Glick. But the big difference was, before 89, anytime a police officer used force, the way we judged whether or not their use of force was reasonable was based on the 14th Amendment to the Constitution, part of the due process part of the Constitution. So what that meant was, as we evaluate a police officer's use of force, we had to look at what their subjective intention was. As a police officer, as I arrive on the scene and a situation escalates and I end up using force against somebody, a judge or a jury, to decide if I used excessive force or not, had to figure out what I was thinking of in my head. Was my intent just to gain control of this guy and handcuff him and take him to jail? Or was my intent really to be mean and cruel and to do mean things to him? So it's very subjective. So in the Graham case, what happened, this is a case that came out of North Carolina, Charlotte, North Carolina. And what happened in this case was a police officer stopped a vehicle that he had seen pull up to a convenience store and leave real quick. The police officer thought that possibly they had robbed the convenience store. When he stopped the vehicle, there were two people in it. The passenger in the car was actually a diabetic. And as the police officer was doing an investigatory stop, trying to find out if they had robbed the convenience store, the passenger gets out of the car and starts having some strange behavior. He runs around the car, does some weird stuff, and won't comply with the officer's commands. Force is used against him. Matter of fact, he got injured. He got his foot broke and some different injuries. And come to find out, he had not robbed the store. He's a diabetic. He was trying to find some juice to drink to stop that insulin problem that he felt coming on. So it went all the way, they sued. Graham sued Connor, the police officer. It went all the way to the Supreme Court. And what the Supreme Court said is, we no longer need to use the 14th Amendment due process to determine whether or not the amount of force that we use is correct. We shouldn't think of the subjective intention of the officer. All uses of force should be evaluated under the Constitution of the Fourth Amendment to the Constitution on search and seizure. So it was a landmark case, and it's still the case today that we look to determine what the rules are, what the law says about reasonableness of our use of force. So the thing that happened to us with this new force standard that was set out in Graham versus Connor and it becoming a Fourth Amendment search and seizure issue, what the court said is every time a police officer uses force against somebody, it's a seizure. Whether it be a soft amount of force all the way up to and include deadly force, that's a seizure. They also said that because it's a seizure, the Fourth Amendment says that the people will be safe and not have an unreasonable search and seizure done. So that reasonableness standard now needs to be applied to uses of force. It doesn't have anything to do with what the subjective intention of the officer is. It has to do with, would another police officer in the same situation have done the same thing? Is that reasonable? And they even told us how to judge it and how to look at it, which is how we, as a department and as a review process of our uses of force, it's the standard that we look to in determining whether or not any use of force by a trooper is reasonable. The other thing that a lot of people, I think, have a misconception about is you hear the word minimal. I've heard this in classroom settings. I've heard it in courts and trial that I've been to, where somebody will make the statement that a police officer needs to use the minimal amount of force necessary to effect the arrest. And that sounds good, use the minimal amount of force necessary. The problem with that is if we have a minimal standard, then I have to try something way down here that could possibly put a trooper in jeopardy of getting injured. So the court never said minimal. Matter of fact, what the court said was that these situations are so fast moving and evolve so quickly, and it's not in a sanitary nature. I mean, it's very dirty, it's very violent, that a trooper or law enforcement officer has to make a split-second decision. He doesn't have to go to minimal. He has to go to something that's reasonable to believe that he'll be able to defend himself, take control of the person, and take him into custody. So it's not a minimal standard, it's a reasonableness standard based on the Fourth Amendment to the Constitution. What that tells us is that there's only two reasons a police officer can use force. If you use force as a police officer, every time you finish using that force, you need to be able to answer this question. Was the amount of force or the type of force that I used, was this a control arrest or a defense arrest? And here's what I mean by that. A control arrest is when I, as a state trooper, an officer of the state, I've either witnessed or I've got probable cause to believe that a crime has been committed. So I've got probable cause, and once that's there, my only desire is to take this person into custody. There's no fight. There's no situation where this person's really going to hurt me in any way, and I'm just going to take them into custody, and it's going to be a controlled type of arrest. The courts have said in a controlled type of arrest, injuries are going to be pretty low. Even in the Graham case, it was only a controlled type arrest. There was a small injury, he got his foot broke, but those injuries aren't going to be life-threatening. They're going to be minor types of injuries. If it's a defense arrest, it's no longer person versus state. It's person versus person. It's me as a police officer, me as a state trooper. I have the right to defend myself and to go home safe at the end of the day. So if I can articulate that this person that I'm trying to arrest is doing something that could harm me, then the courts have said we understand that once it turns into a defense type of an arrest, injuries are going to go up because bad things can happen. I mean, police officers die every day making traffic stops. So it turns into a defense mechanism, and the courts have said we understand that injuries are going to be much greater when it's a defense type of arrest. So we always look at the force, we always look at any situation, and we want to determine was this a control arrest or a defense arrest.